I think it is high time to start because we're already 10 minutes into the time. The organizers are ready. We have one online participant. So without further ado, let us get started. We have today two themes, but one common thread. And the common thread is the general right under international law to take a countermeasure and the role which this right of general international law can usefully and should usefully play for upholding international law. One area, and we will start with that, is the WTO agreement itself, then other trade agreements, and that with a specific situation in mind where dispute settlement is blocked in the WTO or not available, or states choose their right to enforce unilaterally when there is no barrier to that under other agreements than the WTO agreement, which, as you all know, has that barrier. Later, we will move into areas like human rights breaches or breaches of the ban on the use of force, and the role which countermeasures can and should play in this area in a much bigger way than was so far recognized. So in a sense, we are putting an old question, very basic, very foundational, and this is not the discovery of this panel. And you will not walk away from this session with learning something new about international law that you didn't know already. But our aim is to show the relevance which this has today in a way which in the past was either not recognized or because the facts were different and therefore it did not matter when these things were first discussed and published on 25 years ago. I will introduce this panel to you. I will do it in brevity, but also in connection with the subject of today. Geraldo, Vidigal, to my right, is a professor of law at the University of Amsterdam, and he is a generalist of international trade law in the best sense of the word. And he has, in the recent past, observed and commented on the situation at hand in the WTO and what this means for enforcement. Also a little bit because Geraldo is a native from Brazil and he teaches and lives in the European Union, and those two WTO members are somewhat relevant in this connection. Our second speaker will be Cornelia Furculita, who I hope is online. I was told she is and can hear us. Would be nice to hear that being confirmed.
Yes, I can hear you. Hi.
Excellent. Thank you so much. Cornelia is research fellow, associate research fellow at the University of Speyer, and she has blogged and written early pieces on the scope of Article 23 of the DSU regarding the enforcement of WTO and non-WTO rights. To my left is Professor Satoru Taira, Professor Emeritus of Law at Osaka City University. And Satoru has published a good year ago a fantastic article on the limitations of WTO security exceptions even in a war, and on the fallback alternative of justifying trade restrictions as a countermeasure. Gabrielle Marceau, professor of law at the universities of Geneva, Ottawa, and Laval, of course, formerly WTO Secretariat, was amongst the first to reflect and write about the possibility to invoke non-WTO defenses in dispute settlement, including for the enforcement of human rights obligations. Gabrielle's thinking may have evolved. We hope to hear how. And I am Lothar Ehring, a trade lawyer at the European Commission. I have followed this subject over all those years, also at work to keep the EU on a sound track on this. And more recently, I have modified one EU regulation to make possible the enforcement of WTO rights when dispute settlement is blocked, and created another regulation allowing countermeasures against illegal coercion. I speak here in my personal capacity. Professor Vidigal will now speak 5 minutes on the permissibility of enforcing WTO rights when WTO dispute settlement is blocked. We all know that the WTO dispute settlement system is a special system of enforcement that departs a bit from general international law. It is sometimes stricter than general international law, sometimes it's more generous than international law. All this was a package and a balance when agreed and as practiced and applied for many years until things got out of balance. Geraldo.
Thank you so much, Lothar. Thanks for the generous introduction. I'll begin, let's say we are all going to talk about this subject, so the way I'll begin this is by situating us in terms of the general international law applicable to the issue. I will skip over the, what happened during the GATT. So that's, you used to have adjudication under the GATT, under Article 23.2 specifically. And then this adjudication took place at the same time as there was a lot of ad hoc litigation solving important problems. For example, the chicken case from the chicken wars, and more importantly, for present purposes, while the U.S. in particular felt itself at freedom to retaliate unilaterally when it felt that other parties were defaulting on their GATT obligations. So from there comes the keystone of this discussion, which is Article 23 of the DSU, which is by which the members of the WTO engage themselves not to declare other members in breach of WTO law, and also not to respond unilaterally to breach of WTO law. And this which has been interpreted to mean that the WTO has exclusive jurisdiction and all kinds of other things. I'll leave this to others, especially Cornelia, who speaks after myself, but I want to take us back to 1978 and to outside the WTO system, start with, so 1979, and the 1980 ICJ ruling or judgment on the diplomatic and consular staff of the United States in Tehran. So this was a case that happened, and where the ICJ came up with this idea of self-contained responsibility regimes, and which is what we think the WTO is, and which Article 23 of the DSU is generally interpreted as making the WTO. So what happened in this case was that there was the invasion by some non-governmental forces of the U.S. embassy in Tehran, and the U.S. brought a case to the ICJ. And one of the things that an Iranian representative claimed was that it was justified. In any case, this would have been justified because the United States had been engaging in a practice against Iran, et cetera, and the court looks at this and says, well, no. And here's where the court says that the Vienna Convention on Consular Relations has its own system of remedies, which the court says are entirely efficacious, if that's how I pronounce this word. And that therefore it is a self-contained regime, and Iran is, as a consequence, not allowed to apply countermeasures by allowing its citizens to invade the U.S. mission. So you can declare persona non grata, you have other remedies under the Vienna Convention on Consular Relations, and so this was the underlying issue. And this is important, of course, because the court is sort of merging two issues. One is the substantive question of what you're allowed to do in response to violations of the international law in general, and it doesn't sound like invasion of diplomatic and consular missions is one of the things that you're allowed to do. So that's a substantive question, regardless of what happens. And the other is whether you can take measures outside or whether the fact that the convention has remedies within it means that you cannot go outside the convention and adopt other remedies. But that's that's the bit that survived. So in 1982, Willem Riphagen from the International Law Commission sort of creates a code for this and speaks of this as a subsystem of international law. So it's a subsystem of international law because it has its own responsibility rules that displace the general rules of responsibility of general international law. And here Willem Riphagen says, well, but the system as a whole may fail, in which case, you may fall back onto a different subsystem, and more so that would be general international law. Moving 20 years down, so the ILC articles in the end contain this idea that there can be lex specialis regarding responsibility. And mentions as an example WTO law as a system where only the consequences provided for in the DSU exist, and that other parties may not, therefore, adopt countermeasures. So this is again stated in the commentary to the provisions on countermeasures. So which means that there are two questions for us, right? So one is, to what extent does WTO law actually prohibit countermeasures? And the second question is, if it does prohibit countermeasures, then under what conditions could you declare this system to have failed, at least in the sense that the responsibility regime established by the DSU no longer operates, and that therefore you're entitled to adopt measures in self-judging manner. Besides Article 155, and that's the last thing I'm going to say, there's also Article 52.3b of the ILC articles, which is the one that provides that you are not allowed to adopt countermeasures while an issue is pending before a tribunal with the power to act, and which, by analogy, we can think of in terms of using this provision to say, well, okay, if what WTO law really means is that it has created a system that allows members to go to the WTO dispute settlement and to obtain a right to apply measures in response to non-compliance. And therefore, without this system, we could, by analogy, apply, but this is not, of course, this is not a falling back onto general international law, but an analogy, right? You're saying since the same way as in the WTO system as provided for or as expected to function, you would be able to obtain unilaterally a ruling by the appellate body and consequently to apply countermeasures as a response. Then if you don't have the system operational, which is what happens these days, then you would be able to then adopt countermeasures. And I'll leave it at that.
Thank you very much, Geraldo. This is something that can also be traced to the works of the ILC when coming up with the state responsibility articles, which in their final version and final report don't say a lot about this, but drafts going back to the 80s addressed specifically the possible situation of regime failure. And the reports of the special rapporteurs, Riphagen, Aranjo, Ruiz, they go into this at some detail, and they all say when the system, the special regime does not work, the fallback of general rights is available. In the 90s, eminent scholars such as Laurent Bartels, sitting here in front of us, has written about this. Bruno Zimmer, also an ILC club, has written expressly about this. Michael Hahn, who is not here but well known, has covered this in his doctoral thesis. So this all happened right at the time when WTO dispute settlement was in perfect shape, working very well, but already then there were people who thought about what the implications would be if a situation like we have it now arises. Nevertheless, it is also clear that this would be and will be controversial in the WTO, and not everybody will agree. There will be WTO members who will insist on Article 23 and will say that is it. If you have to wait for your rights being respected forever, that's your problem. Maybe we will also hear that opinion on this panel by other speakers. This panel in general should be a conversation, should reflect the diversity of existing views out there. Panel was not composed with a view of having the most preferred view expressed, but on the contrary, the diversity which exists out there. And later, of course, we will make this as much as possible a conversation also in involving you. We now turn to Cornelia, who will speak to us about the inapplicability of Article 23 of the DSU to the enforcement of non-WTO international obligations, but also how that can become tricky when WTO obligations are nevertheless involved.
Yeah, good afternoon, everyone. So I will share my slides, and as already said, I will talk about the inapplicability of Article 23 of the DSU to the enforcement of non-WTO international obligation. And as Geraldo already said, there is the question, of course, to what extent the more special rules provided by Article 23 of the DSU have displayed the more general ones. Article 23 of the DSU, entitled The Strengthening of the Multilateral System, as already said, prohibits the members to seek redress of a violation under covered agreements outside the system. And according to the jurisprudence, this enshrines the primacy of multilateralism over unilateral self-help. While ILC draft articles establish the more general rules, the Article 55 establishes that lex specialis shall prevail. However, lex specialis, which is Article 23 of the DSU, and there is a general agreement, as said by the previous speaker, that there's a general agreement, and it's also mentioned explicitly in the commentaries to the ILC draft articles. The more special rules, they displace the more general ones only to the extent of their scope, the more general rules remaining applicable to the extent that they have not been displaced in a residual manner. So the question that arises is whether Article 23 of the DSU has completely excluded unilateral trade measure. And the short answer to that question is no. Why so? Because of the scope of Article 23 of the DSU is more limited than the scope of general international rules on countermeasure. The jurisprudence, particularly panel in US certain EC products, has explicitly mentioned that the criterion for determining whether Article 23 of the DSU is applicable is whether the member that imposed the measure was seeking the redress of a WTO violation. So the panel was talking only about WTO violations. Furthermore, it was further confirmed by the panel in EC commercial vessels when it interpreted the phrase seek redress violation as covering any act of a member in response to what it considers to be a violation of a WTO obligation by another member. So once again, it only relates to WTO obligation. Therefore, Article 23 of the DSU is not applicable to redress of WTO violations, even if those would be simultaneously in breach of WTO obligation. And this interpretation is also confirmed if we apply the general rules of international law of interpretation enshrined in Article 31 of the Vienna Convention of the Law of Treaty to establish the ordinary meaning of this phrase. So first of all, the terms of the treaty explicitly mention only WTO violation, and it would be against the principle of effective interpretation to not to give meaning to these words, because had the members intended to for Article 23 of the DSU to exclude in general or any type of reaction to any violation, they could have mentioned so, but they mention only violations under the covered agreements. Furthermore, the object and purpose of Article 23 of the DSU, as the title itself suggests, is to strengthen the multilateral system, and it does not exclude having action outside the system. And the context, as the panel in EC commercial vessels said, provides specific remedies, specifically Article 22 of the DSU. So the Article 23 prohibits unilateral acts according to jurisprudence only when these results could be obtained through the DSU and not when it is not possible to do so. Since WTO panels have jurisdiction to consider only WTO claims, and I'm not talking here about the applicability of non-WTO law, they cannot consider claims on non-WTO violations and therefore cannot provide remedies in such cases. And it would not make sense to interpret Article 23 of the DSU as prohibiting actions in case of non-WTO breaches. In a similar context, when WTO members sign FTAs and have dispute settlement procedures under FTA rules, and they can impose countermeasures under FTAs, there is a general agreement that such systems do not violate Article 23 of the DSU. Even in cases when FTA parties would seek seek redress of an FTA violation, even in case when such a violation would concern WTO incorporated norms in FTAs. And it makes sense to do so because even in case of WTO incorporated FTA norms, these breaches are part of a broader context and a broader dispute. And for example, even a WTO incorporated norm could be interpreted differently due to the difference in context, as it happened in the case of EU-Ukraine Association Agreement, and there was a dispute, and the panel said that Article 20 GATT incorporated norm was interpreted with more flexibility, as the panel itself stated, because of the difference in context. However, the mere statement that a measure seeks the redress of a non-WTO obligation, of course, should not be sufficient in order to establish whether or not Article 23 of the DSU was violated or not in a typical approach of de facto de jure violation. Of course, it also matters that the measure is actually designed to seek a redress of a non-WTO violation. And previously, the jurisprudence, particularly the panels in U.S. certain EC products and U.S. Section 301, have looked into different evidence to actually see whether or not that measure was seeking redress of a WTO violation or not. So they looked into accompanying administrative acts, state practice, statements before the panel, press releases and conferences, memoranda of official, and so on. Furthermore, also according to the panel in EC commercial vessels, it matters whether or not the member seeks or initiates parallel WTO dispute settlement procedures. And if it does, this could be used as evidence that, in fact, the member was seeking the redress of a WTO violation. Or if it makes the measures contingent upon the continuation of WTO procedure, which could again be used as evidence in favor of the conclusion that the measure was in fact seeking the redress of a WTO violation. So even if a member imposes a measure and says that with that measure it seeks the redress of a non-WTO violation, it shall do so in a very cautious manner and takes utmost care in how it designs that measure, how it presents it in different other acts, and how it designs other accompanying acts or even press conference and press releases. And it should also avoid initiating parallel WTO dispute settlement procedures to actually confirm its intention to seek the redress of a non-WTO breach. So I will stop here. Thank you.
Thank you very much, Cornelia. Allow me one follow-up question to tickle out one very subtle nuance on which I had hoped we have our first point of important disagreement, but now I'm a little bit less sure, so I have to ask expressly. You said at the end, WTO members should avoid initiating WTO dispute settlement when it is in parallel enforcing a non-WTO obligation. Let's take the simple case, national treatment under an FTA, national treatment under the GATT. There can be no forum choice obligations, or parallel disputes would probably not be very sound, but not prohibited. So imagine that scenario. And you say you would advise against doing that because the WTO dispute can serve as evidence that you are trying, nevertheless, also seeking the redress of the WTO breach. I agree with you when you say should, and this is not very advisable because it's dangerous. But my question to you is are you making a firm statement that this would then automatically be a breach, or nevertheless not necessarily? Given that if I follow you, and that's also what I would contend, one has to intellectually separate the two obligations, WTO and non-WTO. One has to do that even if in content they are identical, because an obligation under FTA is just legally stands in parallel, independent of the WTO obligation. And if we can intellectually separate them, then isn't it possible to pursue both in parallel? Let's say the national treatment breach under an FTA through a direct countermeasure, because that's not prohibited, and WTO with a dispute in that scenario where it is, of course, not possible to obtain the redress of the FTA national treatment breach without simultaneously getting the redress of the WTO breach. What's your answer?
Well, I totally agree with your approach. So when I say it shouldn't, I say this because I think panels would then have evidence to actually say that Article 23 of the DSU is violated. By my personal opinion, is that these two distinct violations should be indeed separated, because the same measure can violate distinct norms. And when the member seeks the redress of a WTO violation within a forum, it seeks the redress of a violation of that particular measure, and it can separate it from the other one. Especially, as I said, even WTO incorporated FTA norms can be interpreted completely different in context. The FTA also can provide different remedies, and it was established in a different context. There could be, for example, the FTA could provide remedies that are not even in breach of WTO norms. So I do mentally separate these two things, but I think that due to the past jurisprudence, it would be cautious from a member's perspective to avoid doing so in order to actually be successful under WTO rules.
Thank you for the clear answer. We now move to Satoru and a different perspective in which countermeasures are important, because Satoru will talk to us about sanctions in response to illegal uses of force and the limitations of the WTO security exceptions.
May I have a controller? Please control. Maybe. Good afternoon. It's very my honor to be here. In addressing our theme, we would like to consider the case of the trade sanctions imposed by many third countries against Russia. Could these countries justify the sanction and the security exception in WTO dispute settlement procedure? The panel in Russia traffic in transit, we call Russian case, for the first time interpreted and applied Article 21b(3) of GATT. We adopt the ruling of this panel as an analytical framework for our assessment. We also take several subsequent cases into account. According to the panel, in Russian case, the invoking state must establish the existence of war and other emergency in international relations. Our first issue is whether the third states can justify their measures under Article 21b(3). All precedents, save for US steel and aluminum products, concern bilateral conflict involving states invoking Article 21b(3). In US steel and aluminum products, the US referred not to the bilateral relation between the US and China, but to the situation of global excess capacity in steel and aluminum. Although the US failed to persuade the panel, this case suggests that a state that has no bilateral conflict with a complaining state may invoke Article 21b3 by alleging the existence of an objective situation as an emergency in international relations. Further, the panel in US origin marking Hong Kong, China, admitted that emergency need not necessarily originate in an invoking state's own territory and bilateral relations, and that a war taking place between two or more countries could give rise to an emergency in international relations affecting other countries. Therefore, our first issue can be answered affirmatively, namely the third state to the dispute between Ukraine and Russia may invoke Article 21b3. According to the panel in Russian case, the invoking state also must articulate its essential security interest sufficiently to demonstrate their veracity. Our second issue, whether third states can establish that the war or other emergency in international relations is objectively affecting their security interest and thus satisfy this requirement. Indeed, Russian action could be condemned as aggression in violation of the UN Charter, and as such would appear to constitute breach of obligation owed to all UN members or the international community as a whole. That is a breach of an obligation erga omnes or erga omnes partes. Therefore, third states may allege that security interests of all states are threatened, and thus that the requirement is satisfied. That being said, there have been no authoritative findings on the part of the UN Security Council or the ICJ of the violation. It seems difficult for a panel to admit such an allegation by third states unless it makes such a finding by itself. Furthermore, sanctions by WTO members for violation of the UN Charter were originally conceived as justified under the paragraph C, but not paragraph B. In reality, third states not directly involved in the dispute may nonetheless be affected in various ways and to varying degrees. Although what qualifies as a sufficient level of articulation under this requirement is not necessarily clear, the panel in Russian case stated that the emergency in international relations is removed from armed conflict. The less obvious are the defense or military interests that can generally be expected to arise. Thus, the third states seem to need to articulate their essential security interests through convincingly establishing that the situation is objective enough to cause a heightened tension or a crisis to themselves that actually threaten their defense or military interest. If the invoking state is required to provide such a level of articulation under this requirement, it would appear that at least some third states would have difficulty achieving this level of articulation. So the second issue cannot necessarily be answered affirmatively. I stop here. Last part I will skip. Thank you.
Okay, thank you very much, Satoru. May I ask you as a follow-up on the two conditions which you have explained and shown on the basis also of the existing jurisprudence, namely, is there an emergency in international relations for the country taking the sanctions vis-à-vis Russia? And secondly, are the security, the own essential security interests of that country sufficiently involved? Would you answer both or at least one of these two questions in the negative if we are speaking about a small island state at exactly the other end of the planet, so geographically very far away, not really feeling itself threatened, but nevertheless being injured in its rights as an erga omnes obligation that there be no use of force by anybody in the world?
So to the third countries, it seems difficult to fulfill the requirement C, especially. So I'm sorry, requirement just articulation of the interest. It's difficult for third countries. So maybe erga omnes obligation, violation of erga omnes obligation is just alleged by the third countries, but there is no authoritative decision of the existence of such a violation. So it's for the panel seems difficult without such a decision, authoritative decision, to admit the existence of the violation of erga omnes obligation.
Okay, thank you very much. We'll return to that problem. Now turn to Gabrielle, who will address for us the subject of sanctions in response to human rights violations and the possible limitations of WTO general exceptions.
Thank you very much, Lothar. Hello to everyone, and thank you to the organizer for a wonderful program. I'd like to say a few things that may not look so coherent initially, and I hope I'll bring them together, but very related to the different dimension of the problematic here. About 20 years ago, I did a series of interviews of ministers and ambassadors from Geneva who were in the green room when the WTO was negotiated, and I had 4 questions to all of them. And one of them concerned dispute settlement. And still today, I'm so happy that I did that, because when it was the 20th anniversary of legal affairs, we cut and kept the things about the dispute settlement in Article 23. And then you had the whole series of negotiators, at least 11 of them, including the US, all saying that all countries were fed up with US threat on 301, and 23 of the DSU was created for that. Because, as you know, probably just the US or a couple of handful of countries could really use unilateral sanctions. So I think it's clear that 23 was to avoid Section 21, and as one negotiator said, it was to put the lion in the cage. put the US in the cage, you will not exercise retaliation until you've done A, B, C, D. Another point, around the same period, I was speaking with Alain Pellet on this issue, and I asked, if I'm correct, if a country put trade restrictions against imports from another country that violates human rights, is it a WTO issue because it's a trade issue? He said, no, it's a human rights issue. Then another one at the table, ILC people, informal lunch, said, no, no, no. That is also WTO because the trade restriction is trade. Well, I concluded it's probably hybrid and you cannot divide them. And this will take me to an extreme case because I had debates on this with my friend Laurent and Joost. Imagine, and I take EU just because it's easy, EU subsidized chicken. The subsidy is WTO consistent. The chicken are exported to Africa. The importing country says, I block these imports because it kills my little industry. And in fact, I even argue it's violation of use coherence because the subsidized chicken drives my population to economic slavery. Some would have argued, and my friend Joost including, the WTO judge should deal with this argument and say, well, is EU violating its human rights sort of obligation? And he would conclude something like maybe the tribunal panel, whatever, should not go into a full conclusion, but could and should end up saying there's no WTO violation because use coherence is above WTO. There's very few obligations. And arguably, this was the position, the WTO judge would settle all these conflicting obligations from different regimes. I don't think it's the job of the WTO to do that, and I don't think the WTO has ever done it. I think the appellate body on 2 occasions was clear that it is created to deal with WTO issue. But the other point important is that non-WTO norm very often come in the context of defense or in the context of preferences. EU saying, I will collect 10% tariff, but you as a developing country, if you don't violate human rights, if you ratify human rights and this, I'll give you a better tariff. But you other country, if you start violating, I'll raise up tariff. Is this human rights or trade? Isn't it a mixed? And this idea that you can put 2 parallel silos and deal separately is not that simple. And it's not realistic, I think, to say that you could always deal with one and deal with the other because human rights in this context, and then I'll come to the point here, is part of the justification for the trade restriction. And one of the most beautiful legacy of the appellate body is to insist on the fact that market access rights are all very important, but defense and justification are also important because government deal with many policies. They don't do only trade. So human rights will come up or could come up in the context of just that, either a preference or a restriction, positive or negative, where the country that put the restrictions or give a less good tariff will say, I have a justification. I do that because I believe in human rights and I want to respect human rights. And the WTO is a very complete system. So yes, 11 says you cannot impose restrictions, but 20A says you can put restrictions for public moral reasons, and the case law has interpreted that very broadly. So if you ask me today, is it possible to impose restrictions for human rights reasons? I would say yes. You can put restrictions for human rights so long as you argue and develop that it is of public moral nature. And as I said, it's pretty broadly defined. Now, can you put all human rights under public morals? I don't think so. But then it depends on which human rights. We always talk about the fundamental human rights violation. But there may be, and I haven't done a sort of scrutinize all the existing human rights. The concern of some is that you could stretch too much 20 and 21 and put everything there. This would make a coherent system because you would never need to go outside. My response to the question, can you fit all human rights violation in 20 or 21? I'd like to say, I don't think so, and we should keep the door open to conceive of some human rights violation that would not fit. Now, last point, today. Today, the dispute settlement system, and in particular, not the appellate body, but the fact that the subsequent steps after adoption, multilateral surveillance, retaliation, the suspension, this is a fundamental right of states. The right of countermeasure is inherent to states. All states have the right to exercise countermeasure. In the DSU, this right was limited. US, you won't impose human countermeasure until you have notified. Maybe go back to the original panel, but then when this is finished, you can retaliate. The DSU did that. Now, the DSU is not working anymore. Retaliation or suspension of concessions under the DSU is simply not possible because there's no appellate body and the system has not been rectified. In front of this, what Lothar calls a failure, regime failure, it is not possible that a state doesn't have the right somewhere, somehow, to retaliate, unless it explicitly agreed. No state in WTO agreed to give up retaliation other than within the parameters of the DSU. So I'll wait for follow-up or subsequent questions, but to your question, I believe that we should look mainly at the non-trade concern when, and this is where it's difficult, when they are invoked in the context of this equilibrium that the AB talked about in shrimp, or this balance between market access and justification. And if this is the premise of the definition of WTO, it's not so shocking that you can fit all non-WTO somewhere in the article that follow 14, that is the world of defense, 14 of GATT, including 18, 20, 21. But today, I think it's a totally different time than when I had these exchanges with Joost and Lauren, because the system was working.
Okay, but I want you to answer now a follow-up question. Please forget the consideration that the dispute settlement system is not working. Imagine, please, that it were working perfectly, or go back in time, 10 years ago, when it was working. Secondly, you say when invoked. So let's imagine a respondent, WTO member, who has enacted a trade restriction, import ban, whatever, no, not whatever, has enacted an import ban on just the main export of the country in question, because that country in question is committing fundamental systematic fundamental human rights breaches, which have nothing to do with the main export that is being restricted. And the responding party invokes Article 20A, Article 20B. Let's say that demonstrators, peaceful demonstrators, are shot and killed without prior warning. It's happened not long ago in a WTO member. Invokes Article 20A, Article 20B, and the right to take a countermeasure against the human rights breach. What would you, if you were the panel or advising the panel, what would you, which one would you pick? Which one would you not pick in that case? I was hoping to hear from you. I still hope now that you also say something about the panel report in DS 543, whether it has any bearing on this in your view, and where a limit may lie in this respect, in Article 20, as a substantive matter. Cornelia explained to us, and I would suggest also accepting that, at least for a moment, that Article 23 is not bidirectional, as is often read and misunderstood. It prohibits countermeasures for the enforcement of WTO rights. But it says nothing at all about trade countermeasures for the enforcement of human rights obligations.
In the case that you described, nobody would bring a claim of violation of human rights to the WTO. I think this is generally accepted.
The respondent does that because it's the way to...
The respondent brings to the WTO the trade restriction, not the human rights restriction. In 543, and I have to disclose that I was assisting in that panel, and I'll be very prudent, but from the reading, the US imposed sanctions because an exporting country would violate, I think it was thieves, IP thieves, and the answer of the panel is this could be 20A, but because some restrictions were removed from the list, they kill their own argument. Because you removed from the goods, from the list of goods, goods that are produced in violation of human rights. Why don't you put restrictions on that? There was incoherence in the argumentation and the justification. But let me answer your question the other way around. A dispute in NAFTA between US and Mexico, where Mexico wins, US does not implement the RTA ruling, and under NAFTA, Mexico has the right to suspend concession. Can Mexico impose a ban of XYZ from US or raise its tariff very high? My instinct reaction, a bit like Cornelia line, is yes, this is RTA, it's parallel, the world is not perfect. We had many meetings about that. And a lot of countries said, no, you cannot use retaliation under the RTA if it violates another treaty. You're supposed to respect all your treaties. You cannot impose suspension. My instinct was, well, the RTA provides for suspension of concessions between these two countries. Why not? So I don't have a perfect answer, but I do think that if you look at your questions of this panel in the context of RTA and WTO, you see that it's not that obvious, but I would tend to think, in answer to your question, that there is room for some countermeasure for trade restrictions, but especially in this context of RTA, because then it's trade restriction on under the RTA. And I'm open to the possibility that there are some human rights violations that cannot be public moral, but to the extent that, you know, the SIEL case, the way you kill SEALs becomes a public moral issue, it's difficult to think of human rights that would not be a public moral issue. And my whole thinking of the system is the first case, so fundamental on that, on shrimp, but also the GSP, the India-Pakistan preferences, that put everything together on a balance. Conditions, therefore restrictions, are okay if they fit in the goal of development. What is development? The appellate body says, look at the UN, they'll tell you more about what is development, but the conditions of the ECGSP are as such possible if objective, implemented correctly, and similarly treating similarly located countries.
Thank you very much, Gabrielle. We move into the final section, which Satoru and I will share a bit. Before handing the floor to Satoru, I summarize a little bit that the preceding four presentations have described situations in which a non-performance of WTO obligations can, in certain situations, depending on the opinion you take, best be justified as a countermeasure under customary international law. Those were situations where WTO obligations are enforced, Geraldo, because dispute settlement is blocked, but no DSP authorization is given. Where non-WTO obligations are enforced, Cornelia, uses of force that do not create an emergency in international relations or do not target or affect the security interests. Or lastly, possibly sanctions in response to human rights breaches. So left is the question whether the right to take a countermeasure can be invoked as a defense to justify the non-performance of a WTO obligation. Is there a substantive obstacle to this? And or is there a procedural one because of the defenses which WTO panels are allowed to hear and uphold? Satoru.
A countermeasure taken by state other than the injured state against breaches of obligation, erga omnes or erga omnes partes, is often referred as third-party countermeasures. Such countermeasures are allowed even though the ILC 24 years ago did not yet feel able to ascertain. Such countermeasures can play a critical role in combating or counteracting breaches of obligation erga omnes, such as human rights breaches or use of force, particularly when the UN Security Council is paralyzed by veto. Article 22 and 23 of the DSU are special rules within the meaning of Article 55 of SIEL, 2001 ILC article on responsibility of state for international wrongful acts. They, therefore, normally set aside customary international law on countermeasures. However, Article 23 only prohibits unilateral measures when members seek the redress of violation of obligation under the covered agreements. Also, we discussed earlier the limitation inherent in Article 23. Therefore, in such a case, there remains room for the application of customary international law on countermeasures for breaches of international obligation. Okay. What WTO panels and AB have applied other international law, including customary, when it is expressly referred to in WTO texts. And also for procedural or secondary purposes like attribution. For non-international law, it changes the outcome of a WTO case. Scholarship has been divided. We contend that panels and the AB must apply the law of state responsibility if invoked. This is the only way to arrive at legally correct WTO rulings. The opponent's arguments are unpersuasive. Indeed, lawful countermeasures presuppose a prior internationally wrongful act. This may require WTO adjudicator to apply non-WTO law, which is an additional challenge. but no valid reason to ignore the law that applies. Thereby, WTO panels, arbitrators, or AB do not become adjudicator of non-WTO dispute, but decide whether the WTO breach is justified. WTO panels could expose findings of fact of other competent organizations, including UN, as a prima facie evidence, unless rebutted.
Okay.
Thank you.
Gabrielle has just told me that she wants to intervene immediately, I hope in disagreement.
Yeah. In disagreement, and very briefly, I agree that, and I think the appellate body and panels have done it most times, when rules on state responsibility are invoked, they may be used for interpretation and all sorts of things, but your concluding comment that looking at non-WTO to decide whether something is justified, a restriction is justified, this is WTO. It's not non-WTO. The question of Lothar was the justification, the search for a justification, is it limited to 20 or can you go outside? The other thing I wanted to say, and I'll stop.
Yeah, and sorry, and what's your answer? Is the defense invocable or not?
My answer to that, your question, is read 19 of the DSU that has treaty provision that says the only thing panel or appellate body can conclude is bring your measure into conformity. Not you violate human rights, you violate this other treaty. You use it in the reasoning to decide, and that's a WTO issue, whether the trade restriction is justified, but not to make a conclusion on non-WTO.
So we ignore the question, the panel should ignore the question whether the countermeasure might be completely legal under international law, but make a finding that there is a WTO breach, and that's all it is asked to do.
You never make only a finding that there's a WTO breach. You need to also explore the justification. And if a countermeasure is legal under international law, I'm not able to conceive a situation where you could not fit it in WTO justifications.
Okay, I hoped we had identified situations where this is so, but I accept that this is an important prior question, which first needs to be answered in the affirmative. And I want to give the floor to Geraldo first, because he was the first to speak, so he could not possibly react to anything he had heard by others. And secondly, you have spoken the least of all of us, and then we'll go into the audience.
Thank you. I'll start by saying that there are some people who say that there's a human right to travel and tourism. I think the World Tourism Organization has stated that. So there's an official document by an international organization saying there's a human right to tourism. I find it hard to believe that this could justify a trade restriction because, you know, the other country isn't respecting the human right to tourism. And I think this is a starting point to say, well, you know, how do you decide, right? So what we're dealing here is a system that, as you say, involves various parallel systems, and more than that, involves in principle a right to auto-interpretation. So what the DSU 23 does is to say, no, you know, under WTO law, at least for the purpose of responding, you do not have I mean, everybody can, you know, think whatever feel as they want, but you cannot act on your own interpretation as a WTO member of WTO law and to enforce the rulings. You have to wait for the WTO ruling. Now, the question is, how do you make these compatible, these things compatible? And of course, the case you're referring to of retaliation under trade agreement has happened. That's U.S. soft drinks. And as you pointed out, I mean, and the appellate body does this quite nicely. Say, what are we supposed to do with this? Are we supposed to accept any claim by Mexico that there is a justification to do this because of non-compliance with the U.S. by the U.S. with the NAFTA obligations? Or are we going to become universal adjudicators? You know, are we going to start as WTO adjudicators saying what is a human right, what is environmentally required or not? Or our third option is to just set it all aside and say, no, you have to find an intra-systemic justification within one of the provisions of Article 20. And that's why, I suppose, Article 20 also became, especially 20A now, is this lightning rod for all kinds of societal concerns, because essentially the door for arguing outside norms as norms rather than as concerns that you can justify has been closed. I will say that what's interesting is that other courts have concluded the same thing without having Article 23. So the Court of Justice of the EU, I think it's Commission versus Luxembourg, maybe, where the court has said, no, you cannot bring a case, you cannot adopt countermeasures under EU law because you have this system where you can bring a case before the CJEU against Belgium, if I'm not mistaken. There's also a Mercosur case where the Mercosur court says the same thing. No, countermeasures are no longer allowed once you have this. And maybe more to the general international law point, which is why I'm here, you have the Air Service Agreement arbitration, right, which is this 1978 arbitration, which provided us with what is the code of countermeasures, which says precisely that. And then this brings us back to the question of, when can you do this? So that says that while there's a system in place that can give you relief, then you're not allowed to adopt countermeasures under international law. But that right ceases to exist if the system doesn't work. So that's a matter of general international, or if the other party fails to implement the system in good faith and allow the composition of the arbitrator, etc. So in terms, just to bring this to WTO law, I think that the question is, as a member, to what extent are you entitled to say, well, the SU is no longer working, therefore I can do this because there's no other time. Let's say, I think the word that Rip Hagen uses is inevitably. So the subsystem inevitably gives way to another system, because of course you cannot have a system where you say, well, and I'm no longer, the system no longer works because I'm not allowing it to work, and also you're not allowed to bring an international case against me. Use countermeasures against me. And the second question, and I'll stop here, is, if you are to do that as a member, what kind of safeguards should you insert into your own decision to make sure that it's not a free-for-all anymore? Right, so how do you transform this from a claim, okay, the system is no longer working, into a system where not everybody is allowed to declare anything they want at any given time? Thank you.
Okay, thank you very much. Laurent, thank you for raising your hand. I would have called on you even without the question, because I want to hear from you on add or diminish, or anything else.
Yeah, I take a pretty strict line on add or diminish. So I think that essentially precludes a WTO panel from reasoning in such a way that WTO law cannot be applied. And we're talking about disapplication on the basis of a right to invoke countermeasures in this case. But I wanted to, if I can now ask my question, if I can limit myself to the case of countermeasures for non-WTO breaches, which of course has nothing to do with 23, as all of you have said. I think it's very hard to say anything about this based on the text. But if one looks at practice, doesn't that indicate a bit what Gabrielle was saying the members said, which is that even the GATT system and then the WTO system were created to move so-called political disputes away. Old Article 86(3) of the ITO Charter said that expressly, that, I mean, sure, it's a long time ago, they said that political measures related to political disputes should be dealt with in the UN. And one can say that that didn't work, so you have a fallback. But that was the original idea. But if you look at practice, there are plenty of cases where countermeasures were not invoked, or where they were invoked, in the Mexico soft drinks case, was thought to be justified under 20D, not in the way that is being proposed as an idea on this panel. Other cases, the Helms-Burton Act, the measure was expressly about regime change. It was justified on grounds of international, in fact, I think national security in that case. So there seems to be a an understanding of WTO members in practice that they should try to fall within the exceptions, even when that fails. And I would even add the air services practice, air services agreements practice. This was the most common countermeasure. And why? Because it's essentially unregulated by WTO law. That would be my hypothesis. So if you look at the practice of countermeasures over the last, however many years it is, 75 years, have there ever been any cases where a right to countermeasures has been invoked in the GATT WTO system? I don't think that that's happened.
Can I ask a question?
Yes, let me just, I will continue, we'll go back, but just so that nobody stays with the last thing you've said, it's not true. In the GATT, Germany invoked the right to countermeasures against Iceland for over a violation of fisheries international law. Iceland took this to the GATT Council and said this is not allowed. Article 11 GATT, and Germany said the right to countermeasures is a right under international law, which Germany has not given up by concluding the GATT. There was a question at the very top, and the rest, Laurent, as a practice depends on what we discussed here. You know, if EU sanctions against Venezuela for human rights breaches are not justifiable under 21, because it's not an emergency in international relations between Venezuela and the EU, or because 20A cannot be invoked, then that counts as practice, and there are quite a few such cases in the decades. So there was above, yes, Gabrielle, please.
What you just said, I think we have to remember that the EU GSP that has human rights component was considered to be WTO, and I think everybody would accept. So a system of preference or restriction is the same thing.
Yeah, but that's a GSP. I suggest that we avoid this further complexity. But fair point, you know, and Article 20 was, I think, also invoked in the original dispute. So there was a second hand at the very top, and then we have two here in the first row.
Thank you. Yuka Fukunaga from Waseda University. Thank you. Sorry for my voice. I have questions to Cornelia, if she is still around.
Yes, I am.
So actually, I'm going to address a very similar issue in my presentation on day 3, by the way, panel 24. So that's why I'm asking the questions. So you said that the same measure can violate both WTO law and non-WTO law, and I totally agree with you on that. But is it really realistic to separate non-WTO violation aspect and WTO violation aspect? I understand that you can, theoretically speaking, you can separate these two, but is it really realistic? And also about, you said that having recourse to WTO recourse may suggest that a country, that member sees the issue as a WTO issue. So you sort of recommend that the member would not go to WTO DS. I think it depends on which non-WTO DS you're speaking about, but, you know, remedies available in dispute settlement are different. You know, in the ICJ, certain remedies are available. In WTO DS, certain remedies are available. So maybe these, having recourse to the WTO does not necessarily mean that that member sees the case as only WTO case. So these are my questions. Thank you.
Maybe you can take all questions.
Yeah, let's first complete the round. And Antoine, I have seen you. You'll come in the next round. Peter, Thomas. Or Thomas and Peter.
Thank you very much. I have two questions. The first one is on point in time. When can we say the system is failing? Is it sufficient to expect that somebody will appeal into the blue, or do we have to go all the way until this happens? And the second one is the GATT dispute settlement is based upon the concept of nullification and impairment. And it's not limited to violation of the law, but it also entails non-violation complaints in any other situations, its cases. What is the implication of this in delineating whether you can take countermeasures under international law or WTO law? Thank you.
Peter?
And I had two questions. But the first question actually, Gabrielle already answered, because she threw in the audience the question whether all human rights that are recognized in international agreements would fit Article 20A. And then later on, you said, well, look at what happened in EU SIEL products. And I would agree, yeah. There I was, as a European, told that the welfare of seals, and we're not talking about the baby seals, we're talking about the blubbery big animals, that is part of my moral concerns, public moral concerns. So I think all human rights that we find in international, but I think my question is perhaps a more technical one to all participants. Imagine a situation, well, the comment was made a few times that the DSU, the dispute settlement system as a whole, does not fully work anymore. But consider the following situation. The respondent is an MPIA party, and the complainant is not and chooses not to be. Can that complainant argue that the dispute settlement system, of which the MPIA as being arbitration as an integral part, does not function, and on that basis of the not working of the DSU, choose to adopt countermeasures? My answer would be no, but I'm interested what the panel has to say.
Thanks. So 4 more. I hope we'll get to a second round, but it's too much to add all now. Who wants to reply to what? Maybe we start with you this time.
Sorry, my language ability is not good, so it's difficult to answer.
Whichever you want, but also you're not obliged. It depends on whether you felt that any of the questions were directed to you. I'm not sure. In fact, I have not spotted this, but it's also for you to judge. Why don't we can also start with the others, and then you can reflect whether you want to add anything. Cornelia, why don't we start with you then?
Yes, thank you. So I think in some respect, my statement that Article 23 of the DSU does not prohibit seeking redress of a non-WTO violation could have been perceived that I suggest that it also means that these countermeasures are or should be substantively justified, which is actually what it is not actually my idea. My idea is indeed Article 23 of the DSU, as everyone agreed, does not prohibit recourse to or does not prohibit seeking redress of a non-WTO violation. But in that case, if countermeasures are adopted under general international law rules against non-WTO violations, those countermeasures, from my perspective, do not violate the procedural rules of Article 23 of the DSU, but could violate substantive violations. And to seek the balance that Gabrielle was also talking, that members do not perceive the fact that they are allowed to violate WTO rules, I think substantively those countermeasures need to be justified under WTO exceptions, basically Article 20 A, B, or C, or Article 21 B3, or there's a different question about applying the fallback doctrine. And in this respect, as also was already suggested, and I have written about this, I strongly believe that the fallback doctrine cannot be invoked by MPIA members. Parties, because in that case, the system cannot be said to fail. Moreover, I think that there is the customary law has not solidified yet into determining what a failure in fact is, and that is a problematic aspect because some may argue that the failure is already the system is already in failure, or other could argue that, for example, parties can still pursue even outside the MPIA other alternative dispute resolution methods, or they could negotiate and reach multilateral or mutually agreed solution. So in that respect, I think the customary law has not yet solidified, and this might be a problem with respect to the fallback doctrine. And with respect to the question that I have been asked also in the audience, as I said, yes, I truly believe that aspects can be differentiated. A member could seek a redress of a non-WTO violation because the same measure can violate different aspects. But nevertheless, it is very difficult to actually separate this. So in that respect, I think, as also suggested, there was a question online by Brett Williams saying that for example, wouldn't that breach Article 2.1b? Yes, I think it would breach Article 2.1b, and there would be a need for a justification. So I think there is a way to balance. And from exactly that perspective, Article 23 of the DSU cannot be violated when a measure is justified or could be justified under one of the substantive provisions, because it would not make sense to violate Article 23 of the DSU while also justifying the measure under Article 20 or under Article 21. So if that answers the question. Thank you.
Geraldo?
Yeah, so, when is the system failing? And I think the MPIA, I think these are both go to the same point. Mm-hmm. So the question is, what are we doing right here? So is this, we've got news to this highly text-based reading of WTO law and practice around WTO law because the appellate body was so strong on saying, let's read the agreement as it is, not try to infer objectives or negotiating results. And of course, under the literal reading, none of this can be done, right? The Article 23 DSU it seems pretty clear to me, and I think you wouldn't be able to do any of this. Another way to do this is, okay, let's read this, let's say, infused by public international law as part of a larger corpus influenced by the ILC articles, etc. And there you can say, well, then you would have to wait for an authoritative reading. If you have the possibility of having an authoritative ruling, then you should wait for it. And in that sense, you could say, well, then that would be what the EU and maybe Brazil were doing up until a while ago, which was, okay, this was, we wait for a panel report. And once you have a panel report, then you have an authoritative ruling and say, well, then you have to wait for the other party to be sufficiently let's say, perceived to be delaying the procedures rather than acting in good faith, because, well, I'm offering you MPIA, I'm offering you ad hoc arbitration, so you can pick one. And if you don't pick any, if you just keep on stalling and coming up with arguments, then I'll declare you in bad faith, and this would, let's say, match what the Air Service Agreement arbitration has said. Or you can say, finally, the whole subsystem has failed, all bets are off, and which seems to be more or less what is happening now, where with parties saying no longer that we have to wait for a panel report, but we just can declare, which, by the way, was always what the U.S. does. I mean, the U.S. 301 was never conditioned upon, I know you had the case, etc., but would they say the very smart panelists found a way to declare the U.S. in compliance as long as they didn't trigger the possibility of unilaterally with the suspending WTO rules, but that was always the U.S. legislation. But it seems that other members are now thinking, okay, we have to be able, and again, there's a certain reading of the general public international law that says, if you feel that the system cannot bring you relief in any case, then you're basically declaring the failure. When does this happen? I think, let's say, if you were an actor acting in good faith, you should still wait for the behavior of the other member to demonstrate that they are not willing to allow disputes, at least disputes of a certain kind, to be settled by a multilateral body. Thank you.
Gabrielle, also briefly, please. Yeah.
Very briefly. Let me take an example which to me prove that we should be very prudent in distinguishing obligation instead of trying to read them together. Think of an MEA, Multilateral Environment Agreement, that prohibits its members from trading on some sort of wood. So import restrictions imposed on this product with non-MEA members. We have, I think, 20 or 25 MEAs that have such thing. If a party to the MEA blocks importation of this product coming from a non-MEA country, is that country imposing or enforcing MEA? Is it an MEA question, or is it an environment question under 20G, where the country restricting this product will say it's dangerous, it's bad for the environment, look, I also signed this MEA, I'm coherent, and I have to block this trade under the MEA. Is it an MEA issue or a WTO? And I would go back to my initial modest comment. Government deals, I've never worked for any government, but deal with many policies at the same time, and they often overlap in their legal instruments. So when a country blocks importation because it has to do it under an MEA and it justifies it under 20G, I'm asking you the question. Are we outside the WTO or within? And I hope, Peter, you'll have the time to elaborate, because this is relevant today. Very relevant, this question. That's why you're so wise, Lothar. Because we have a big player who's violating things, arguably WTO rules on tariff, but other things, coercion and all that. Can Canada and EU start saying, I can use countermeasure under international law? Yes, it's tariff applied, but it's coercion and it's threat, and it's going to get very complicated.
The world is certainly complicated. Satoru, do you want to add anything?
So I wrote in my article that measure that is lawfully in the macrocosmos of the international legal system will end up being unlawful in the microcosmos of the WTO. Would WTO members caught in such a predicament really want to remain in such a microcosmos? It's my first question for me, from me. So I cannot answer anymore. Thank you.
Thank you very much. There's only one thing that was not addressed by anybody. That's Thomas's question on non-violation notification or impairment. I've deliberately removed this, kept this away from our program to keep things simple, but I can assure you, some of us have thought through also this angle. And a short reply, I think it's relevant only in one direction, because NVNI exists practically only in the WTO and nowhere else. I'm simplifying a little bit. So it is relevant only for the question of, can I enforce my procedural right, NVNI, when dispute settlement is not working by fallback to general international rules? My answer to you is no, because in general international law, there is the countermeasure which requires a breach, a wrongful act, and a non-violation notification impairment is not that. You can get to a different result only if you rely not on general international law, but on your WTO right to a remedy. And you say, I'm entitled to this, and I have to get it, even if these objective obstacles that I'm not responsible for stand in the way. And I think personally that does not work. It's the DSU that provides you this, and the DSU does not work. But you see the argument which can make this work. Now, in closing, I just want to highlight that you have, of course, realized, and Gabrielle, thank you for mentioning expressly at the end, and apologies that we couldn't go into another round of questions for reasons of time. You have realized that all this is relevant, not least because of the situation created by the United States in the WTO dispute settlement system, but also vis-à-vis the United States in response to the trade measures it is currently taking. And as we have not much discussed now. The United States is, of course, in a slightly different situation. The United States, if it appeals into the void, you know, it's not just that dispute settlement doesn't work. It also doesn't work because the United States has breached its obligations under the WTO agreement to keep it working. So there is an additional basis allowing you to possibly go further, and possibly also if you make a projection that if you file a case to a panel that this would not get you anywhere except to an appeal into the void, that maybe in that relation you might not even be required to go to that point where you then see an appeal into the void. But the other questions we discussed are also relevant here. United States has concluded international agreements, some of which give similar obligations as WTO and are breached vis-a-vis the bilateral partners. The United States has concluded international agreements with its two neighbors, which say expressly, notwithstanding the WTO agreement, retaliation is allowed in this situation. And in that situation, then, the United States challenges those measures in the WTO and says expressly there is no WTO justification. Yeah, it's the same state that signs an international agreement which says notwithstanding. So that's not even the right to countermeasure. Can you invoke that? Or is this something WTO panels must ignore? I hope we have fleshed out these questions a little bit. If you heard different angles and sometimes very different views here, that was by design and not an accident. I just want to leave you with two things, which are seldom said or recognized. One is when people say that the WTO agreement does not provide for the right to take a countermeasure, please give me and send me, if you find it, one international treaty which says that the treaty obligations may be non-performed as a countermeasure in response to an obligation outside that treaty. Yeah, inside the treaty I can also send you. But I think what we're discussing does not exist. No treaty in the world says that. That is said in general international law, which if it does not apply to all treaties, then we have a contradiction. The general international law applies to all treaties. Second point is developing countries in the past were very wary of non-WTO justifications for trade restrictions. And you may know the reasons why. But in this area, things have changed. India has relied on the invalidity of the WTO obligation, which was advanced by the complainant in a dispute with the European Union. European Union agreed that this invalidity under general international law would be relevant. Panama relied on force majeure as a justification for non-compliance with WTO obligations. So these things are relevant also outside the question of countermeasures, and we hope to have elaborated a little bit on these important
Lothar, 10 seconds. WTO does not say you can or you cannot use countermeasure. It says if you want to use countermeasure, you must need first to do step A, B, C, D. That's what 23 arguably has done. Not prohibit or authorize countermeasure, but regulate them. Put the lion in the cage.
And you want to have the last word? I thought Gabrielle should have it, but Geraldo, you can have it.
I'm a bit disappointed that no one has started any other situation case as of yet, because then, I mean, you couldn't appeal that into the vote because there's no appellate body report on that. So yeah, that would have been a very interesting thing.
It's not binding panel report situation, 26 DSUs.
Okay, yeah, we could, yeah, but the question, would that then this give you the authoritative ruling or the authoritative document you would need to then say, okay, then, you know, what exactly can we do in this
No way, because the panel report must be adopted by positive consensus, and retaliation can also only be authorized by positive consensus. Thank you very much. See you later.